Done.
Good afternoon, everyone. Today we are here on Independence Day with Mr. Thomas Valenti. Here he's an attorney, mediator, arbitrator, ACI, ARB, Chicago, Illinois. Sir is a Chicago-based conflict resolution specialist offering mediation, arbitration, and facilitation services and training globally. We are here in continuation of our Super 100 webinar series, and today we are interviewing Sir about the accomplishments and the challenges Sir have faced. Now with me we have Kumar Rishaparth as a moderator and interviewer. He'll be going forward with the questions. Kumar, can you please begin with the first question?
Surely, Arus. Thank you. Thank you, sir, for coming on board with us. So the first question is, why the law? In the college days, what influenced you or motivated you to do law or to pursue law?
That's a good question. And first, happy Independence Day
you,
to everyone in India. And thank you, gentlemen, for having me on this session. Your question has a bit of a mistake in it because you said, why college? But my story is a bit different. For some reason, I knew in high school, before even college, I knew I wanted to be a lawyer. And I'm not so sure why, but you know, when we graduate high school in the States as a practice, the family gives you some kind of small gift. And my gift was some pictures of lawyers, British lawyers, in gowns and hats and all that. And that was what I was given in high school. So it was almost, for me, my destiny. You know, I somehow had expressed some interest in that to my family to the extent that even before entering college, they knew that was going to be my career. And so I didn't have the agony that lots of people have going through college is, what am I going to do with my life? I knew that then, and I think it was probably some interest that my family, no one in my family is a lawyer, but maybe somehow subtly my dad was putting some kind of psychology on me about practicing law. He tells a story that he was the only one in his family who went on to school, and that he wanted to be a lawyer himself, but the profs at his school said, no, you're meant for business, don't go to law. And so they steered him away from law. And so, but I embraced it. I thought it was going to be a wonderful career. In college, then I studied political science, some government things. I had some kind of internships relating to government, and then even in the summers began interning at the lawyer, kind of a distant member of the family. So I started running errands and things like that. So I was very excited. I didn't know what I was going to do when I began my law practice, but I was very excited to fulfill my goal early on.
Right, sir. Arush, you go on with your question.
So sir, this question is really inspiring for a lot of students. So as a successful arbitrator, what is the toughest challenge ever faced in one of your cases?
You know, that's I can think of a story. It's rather recent, and so as all of you know, in arbitration, sometimes we serve as a sole arbitrator where it's just you or me individually making decisions, and sometimes it's a panel of three. This was a case, and it's interesting that because in the COVID era, we're doing everything online, but in the pre-COVID era, there was a request made to the tribunal that the lawyer for one of the parties, this was a financial arbitration. It involved some financial issues between brokerage companies and a client. But the attorney for the claimant asked, at the very last minute, asked that he be allowed to participate online. And keep in mind, this is not, we weren't thinking about COVID or anything like that. And the challenge at that point was, and he had no one to be in the room with us. So we were going to be in a center, the three panel members, the respondent and her attorney, I'm sorry, it was the respondent's request, not the claimant's response. So the claimant and her attorney, and then who was going to be there from the respondent. And I, as the chair, I said, I don't mind it. There was a particular family reason that he couldn't leave home. And I had heard that he made this request quite frequently. And I said, the problem is we as the members of the tribunal can't become his associate attorney. Passing exhibits or witnesses, it would look like favoritism, right? It would look like we were helping him defend the case. So we tried to get some assurances that the tribunals weren't going to be his law clerks or his interns or his associates. And he said, my clients can manage all that. And so he said, fine. And so we began the hearing, and it wasn't a one-day hearing. It was scheduled to be a 5-day hearing. And so it became very clear that his ability to use his client as a law clerk and his ability to use the technology and even to refer to exhibits by page and page number and all of that was quite challenged. And so we were faced with, and I as the chair, of trying to help him with his case without becoming an advocate for him, right? Being on his team. And it was not easy because he had a certain senior status and was a bit agitated about things. And when we began to help him, it often had to be in a way that was correcting him because he was referring to the wrong exhibit number or page number. And we were trying to sort that out without making it look like he was making a lot of mistakes. And so it was quite challenging. And it went on for 4 days. We finished before the 5th day. But it taught a lesson on how to be neutral, which is the challenge of the arbitrator. Let them get a full hearing, which is our job as well, is to make sure that there's no appeal because their ability to defend or prosecute their case was not hampered by the tribunal, and to give him some deference because of age, seniority, and technical difficulties with whatever the platform is and exhibit numbers and pages. So that's a very recent challenge, and it challenges your ability to be neutral, your ability to be patient,
Right.
and to ensure a proper record.
Right, sir. So, is there any advice or suggestion that you would want to give young law aspirants or students who are trying to build their strong career in the ADR field?
The opportunities nowadays, ADR actually includes court litigation. So most of the big firms, even the firms you guys know in India, they all use dispute resolution, including litigation. So nowadays we talk about litigation, arbitration, and mediation, all under the umbrella of the dispute resolution department. It used to be just the litigation department. And so you're going to be in a firm, and especially in India, the firms haven't taken up mediation that well. They have very good arbitration departments, but you're probably going to be in the department that deals with all of those, the court litigation, arbitration, and mediation. Your ability to learn the mediation skills is not going to be that great in the law firm. So I encourage everybody to do, as a student in India, to participate in competitions and see what opportunities there are to study mediation. Arbitration, many of the schools are offering some courses in that, but there's some opportunities in the firms to sit with seniors and learn those skills. And so not for a while will you get the opportunity as a young lawyer to really show the skills you have. Law firm structures are such that the young men and women have to prove themselves, and it takes a bit of time to do that. But I think the best thing you can do is study those firms, take those internships that you have, learn what you can in the schools, and then show the younger lawyers that you're working with and the senior lawyers that you have these skills already. Maybe you've won some awards in competitions in writing skills, argument skills, and all that, and bring that there. And don't be afraid to demonstrate those skills to your seniors. We have, those hierarchical systems that keep you pretty quiet at the beginning. So it's up to you to demonstrate to them the skills that you have. My experience over the past 10 years in India is the students are well studied, well skilled. And so you have that. You just have to have the confidence to bring that to the opportunities that present themselves to you.
Thank you, sir. Right. Arush.
Okay. So, sir, as you have been to many leading cases and arbitrations, what do you consider your greatest achievement and your strength?
Well, we don't, all of that is quite confidential. So we don't talk too much about greatest achievements or strengths or things. But I think the strength I can talk about, it's the ability to make sure that people feel they had a full hearing and that it was fair. And that's really the job of the arbitrator is to make sure that the participants have a good opportunity for the deciders, whether that's me and the two of you, for all of us to hear the evidence. And sometimes that's challenging because everybody looks at arbitration as an informal process. And as a result, sometimes the way the case is thought to be proved is too informal, and that there isn't a burden of proof met by people in arbitration. And so sometimes we have to bend over backwards a little bit to encourage a full exploration of the evidence. And so the strength is to do that in a way that's impartial. The achievements are that we don't get challenged, is that we give the full hearing, and no one challenges that by saying that the arbitrator or the tribunal was arbitrary, didn't let us put on evidence, didn't let us examine or cross-examine as long as we want to. And so the achievements are a clean record with regard to overturning decisions. And so that's what everybody strives for in every case, is an award that cannot be challenged.
Right, sir. Thank you. So, as you travel to countries like Dubai, UK, India to teach various different courses to students, so is there any difference in terms of education and approach you see or you use while teaching?
Not really. One thing that I found over the years that is the same is that no matter where you are, there are students who are very eager to learn. But the most refreshing part about it is, and I know this even from my schooling at a young age here, no matter where I go, there's always a clown, right? There's always some student who has some kind of energy and breaks up the comments are interesting, perhaps funny, and in any country, there's always somebody who's what I call the class clown. And I don't mean that in a derogatory way. I mean that in a refreshing way.
Right.
And because we need that. We need, in the learning process, we don't just want the lecture and all of that. We need some interactive and some way to keep everybody interested in the subject from hour to hour and day to day. In these sessions, sometimes we're going 5 days straight, 8 hours a day, and it can be quite boring. And I don't think I'm always the most interesting person to listen to. So I welcome, when I enter a room, I'm trying to figure out, well, who's the clown or who are the clowns in this class? And then we use them in many of the trainings or exercises we do. We need people to participate. And so I'm looking right away, who are the ones I can call on who are going to be willing to stand up and try this and try that. And so that's, in every country, we see those kinds of students. Sometimes it's a male, sometimes it's a female, but usually it's a male that becomes the clown. But the females are usually more interested in participating. The experiences are different because of culture. And so well, you guys know, in India, you walk into a room, everybody stands up. And in other countries, maybe that doesn't happen. And so those cultural experiences are quite interesting. And as you know, I can't go get my tea myself. Someone has to take it and bring it to me. And there's lots of differences that we all appreciate being immersed in different cultures around the world. But it's quite a rewarding experience for me to experience that and to get people like you to meet them later in life and see how they've matured in their career. And I have students that I've known since 9 or 10 years ago in India who are practicing professionals now. And I remember them in competitions and get an invitation. Some woman's getting married and, we would love to have you in India. And so those experiences are quite valuable to me and meaningful.
Right, sir. Arush?
Sir, I really believe that this particular insight that when conducting workshop, you should search for a clown in a positive manner and make it more interesting is really one tip that I take from here. So,
Yeah.
sir, for the next question, sir, in one of the interviews, it was mentioned that due to pandemic, there is an issue while conducting online hearings, as you cannot observe the body language when someone examines a witness, and moreover, you cannot really see who is in the room. So, sir, how far is it true, and what are the problems are faced in this process?
Yeah, this is a really good question because I've been doing online long before COVID. So I've been teaching online mediation, for several years. So we're used to this. But when the pandemic happened, there were lots of people who had no skills at all. And as you know, in mediation, we value highly body language. And there's a bit of negativity associated with that until people begin to use it and get comfortable with it. I think the better we get at using platforms like today, we happen to be on a Zoom call. This is something I've used a long time. And over the years, they've developed breakout rooms, all kinds of things that we start to use. And I use them quite a bit. And we can actually, with law students in India, we use the breakout rooms and make a team and they go work on something. I pop in and do that. So I'm used to seeing people on screen, encouraging them to keep the cameras on if the connectivity and bandwidth is there. But with regard to the body language specifically I'll talk about mediation first, then arbitration. So everybody said we need to see, above, not the whole body, not just from the belly up or the chest up, whatever it may be. And I've been telling people that online gives you a very unique opportunity, because when you're in a room, usually you're only watching one person at a time. And with the Zoom, if you have your settings right, I can be making eye contact. You think I'm making eye contact with you right now because I'm looking at the camera. Everybody thinks I'm looking at them, right? Because I'm looking at the camera. And at the same time, I see everybody at the same time. So I can be watching all of your body language at the same time. I don't have to look to one side of the table or the other side of the table. So I think it has some unique advantages, and it's close up, right? Everybody is in close up. Nobody is at the end of the table or far away. So I think as we practice and get more skilled in online, that in mediation, we're going to realize that sometimes it can be an advantage. And so some people say, well, you're distant and all that. And I think we teach people a couple of skills on how to make it more intimate. For example, I can lower my voice. If I'm having a private session with you, I can lower my voice. I can lean into the camera a little bit. And it feels like a different thing than if I'm back here and talking a bit louder. So we change our tone. We change our relationship with our camera. And we can do a few things to make it feel different during the course of our mediation. Let's talk about arbitration briefly, and then I'll let you move on, because you might have some other questions. In arbitration, we have these problems, right? Can somebody be in the room coaching a witness? Can they be getting yes or no answers on a smartphone or something like that, or messages on it? And so in the arbitration community, everybody feels that they have to overly protect people from cheating, right? I mean, that we don't want people to have assistance or help, or in most proceedings, an expert witness is allowed to have his report and the opponent's report and no other documents on the table. So we do all these things. So we say, take your camera and pan the room. Let me see your desk. Go around 360 degrees. Make sure nobody's in the room. Show me your phone, and we do all these crazy things to make sure that the process is fair and that there's no assistance that's not allowed in the setting. So we've learned to make some adjustments to give integrity to the arbitration process that we would have in person. There are, there are people who are talking about having extra cameras available in each room so that somebody can look at the desk or do all these things. So gradually, as more arbitrations go online, there'll be some additional things that are available. Zoom itself has just introduced some kind of device, that has multiple cameras and multiple microphones on it and all that. So we'll see the technology match the need as we go on. But in mediation, we're worried about body language. In arbitration, we worry about integrity or inability to use aids that are not allowed in an in-person hearing.
Right, sir.
Okay, sir.
So, any feature that can be brought to international arbitration, and that could really change the efficiency of international arbitration amid this pandemic. What do you feel about this?
Any new thing that can happen? Is that what you're saying? Is what can we do?
Right.
I think what we, from my, I'm not confident that, next month, next January, whatever, we're all going to have a vaccine and we go back to normal. I think to prepare myself, I'm expecting this to be a lifetime event. That we all talk about COVID-19, but is there going to be a COVID-20, a COVID-21? So I think we should be making some adjustments to prepare that this could happen at really any point in time, and we should be ready to shift so we don't have this big lag in time where nobody does anything. You remember back, depending upon what country we're listening in from, court system shut down, nobody was doing anything. It took people a while to decide, well, I'm going to use technology. So I think the shift in transnational work or global work is we all should be ready to shift to some online mechanism right away. And that we should be preparing our if we're practicing lawyers, and we should be preparing our clients to be able to do that and meet immediate needs ready, so we don't have this time lag where there's a bit of a panic. We just go into online mode. And so even if we're getting back into more regular practices in litigation, mediation, and arbitration, we had a story yesterday in Illinois where they went to Zoom hearings, and I don't know who did it, but there was Zoom bombing. The administrator in that, it was a smaller court system. We have many counties in Illinois, so it was a small county. They didn't have their parameters set up on Zoom to prevent Zoom bombing. And so that's what I'm talking about, is we should all be learning the skills, get maybe technology. And I think the answer is to get you guys involved, is get young people on the team, whether they're still in law school, and hire a tech administrator for all of our different sessions, somebody who knows how to move buttons, click this, click that, set this up. And so the young people, you young people around the world have this advantage, is that you can bring your legal skills, but also your technology skills to a firm right away, and teach the lawyers, the partners, and even go out to a client and teach the client how to get their technology up to speed. And I think it's an exciting time for young lawyers around the world and law students around the world to take two things you're very good at. One is studying and learning the law, and the other is technology, and bring that to the law firms who recognize a shortage in that. I spent some time in a few months ago with one of the larger ADR systems. Most of the elderly or senior mediators had no online experience. So we did a training. We taught them how to use this platform because they all thought they were out of business. Somebody said you can't do this in person anymore, and they're all mediating now because we adapted to that situation. And so adaptability is what needs to be done globally.
Right, sir. Right, sir. Very insightful.
Sir, moving on to the last question, I think this is a really crucial question according to me. It's in accordance with dealing with mistakes. Sir, if one ever makes a mistake in a crucial hearing, what is the best way to deal with it?
Okay, as a arbitrator, or I can tell you this, is that the way it works is so we have a hearing that may go for hours or days, and usually in tribunal settings, oftentimes the chair is in charge with making evidentiary decisions in the moment, and so today we or at the lunch break or whatever, we sit and chat, and how did it go, what about this, what about that, and what we can learn from debriefing is maybe we weren't quite right about something, and the key is to correct it immediately. When the parties and their counsel have an opportunity to do what I didn't allow them to do, or whatever it may be. So if I didn't allow certain evidence, and we had a meeting, or I thought about it over my coffee at lunch or whatever, I realized maybe I should allow that. I should go back in the next session and say, I rethought this position, and I would like to give you the opportunity to do that. And that's all on the record. And so if we fix our mistakes early, then we can have a better hearing. If we don't fix it, we then always wonder, did I give these people a fair hearing? And all we have as arbitrators is reputation. And so if you gain a reputation of being someone who not just makes a decision, but thinks about the impact of their decision, then and is willing to admit a mistake, that's I think how we should handle it. We shouldn't decide, well, I made my ruling, I have to justify it from now until I die. We should have the intellectual and integral capacity to say, I rethought this, and I'm going to reverse myself or change my ruling in some fashion.
Right.
Hard for some of us to do, right? We have a lot of pride. We study a lot. You know, we think we always make the best decisions, but as we all know, when in the heat of the moment, sometimes we haven't thought about every possible thing. And to be able to recognize that in a quiet moment and fix it is very valuable.
True. Right, sir. So this was all our questions was, and thank you so much, sir, again for joining us. It's always a pleasure hearing from you and hearing you about your experiences, and these are so insightful that anyone, each and every person, I believe, not only the young aspirants, even the practicing arbitrators, mediators, or the law professionals can learn a lot from you, sir.
Thank you
so
for
much.
saying. I look forward to doing this again. I enjoy this, and keep doing what you're doing, and I applaud the efforts of Legisnations and all the other things you guys are doing. All the best.
Thank you so much, sir. Thank you so much, sir.
Thank you so much.
So we are calling it a day, and thank you so much. We'll be back again with another interview.